Hello, aspirants. A very warm welcome to this Rungta IAS Academy Explainer. Today we're unpacking a really critical Supreme Court judgment. Think of this as a highly relevant current affairs bouncer, specifically for your GS Paper 2 syllabus.
Absolutely. This right here is pure gold for your governance and polity sections. We're going to decode the constitutional expansion of justice for asset ingestion survivors, and more importantly, show you exactly how to leverage this in your upcoming mains and personality test. So let's jump straight in.
Recently, a Supreme Court bench, led by Chief Justice of India Surya Kant and Justice Joy Mallya Bagchi, made a huge move. They officially expanded the Rights of Persons with Disabilities Act, or the RPwD Act, of 2016.
And the crucial part? They expanded it to specifically include victims of forcible acid ingestion under the definition of acid attack victims, because believe it or not, until this ruling, these particular survivors were completely left out of the disability benefits framework.
Which brings us to our first core area, decoding the legal loophole. You see, under the original 2016 RPW Act, the law only recognized victims of acid throwing. It literally ignored those who were forced to ingest it.
Right, and the glaring anomaly here is that the Indian Penal Code, specifically Section 124, already recognized both throwing and forcible administration as severe offenses. We're talking punishments of 10 years to life. So the Penal Code recognized the crime perfectly, but the Welfare Act, it completely denied them disability benefits.
Now let's look at how this was fixed in Section 2, Article 142, in action. During the hearings, Solicitor General Tushar Mehta, who was representing the union government, actually submitted that the nodal ministry had already spotted this massive gap. They'd even forwarded a proposed amendment to the Ministry of Legislative Affairs. Basically, the government's stance was, please wait for Parliament to amend the Act's schedule. But as we all know with our legislative processes, making a law takes time. And that is exactly where the petitioners made a really powerful intervention. Senior advocate Mukul Rahaji successfully argued that time was of the essence here. He hit the nail on the head, emphasizing that these victims are mostly, if not entirely, women. He argued that the extreme, unimaginable agony these survivors face means they simply cannot wait for the wheels of Parliament to slowly turn. They needed immediate relief, no delays. The court fully agreed, stepping in by invoking Article 142. For those of you revising your bare acts right now, remember, Article 142 grants the Supreme Court plenary powers to pass any decree necessary to do complete justice in any pending matter.
It's an absolutely prime example of the judiciary acting to protect vulnerable sections while the legislature plays catch-up. Truly the ultimate constitutional tool to bridge that gap between rigid law and immediate human suffering.
Moving on to our third area, retrospective justice and benefits. Now, here's the absolute game changer. This judicial reading is deemed to be operative retrospectively, right from the inception of the Act in 2016.
That backdating is massive fodder for your answers. It means victims can now rightfully claim the disability benefits they've been owed for years. This includes vital monetary support and the issuance of a formal disability identity card, giving them actual state recognition.
Furthermore, the bench made a really critical observation. They noted that survivors of forcible acid ingestion require extensive, continuous medical treatment. Because of this reality, the court suggested framing a comprehensive policy framework to protect them. It's a clear nudge to the executive to move beyond just legal definitions and actually build a robust ecosystem of medical and social care. Finally, let's talk about the payoff. GS2 mains and interview application. So we have a direct question for you. How are you going to utilize this landmark judgment in your GS2 mains answers and your personality test?
Remember, as an aspirant, you don't just read the news, you analyze it. If a question pops up on the effectiveness of welfare legislation or judicial interventions, how will you structure your argument using this exact case?
Here's exactly how you map it to the syllabus. If a question deals with mechanisms for vulnerable sections, you cite this to show the intersection of gender and disability.
Spot on. And for judicial activism, use this as a textbook positive case study of Article 142 filling a legislative vacuum. If they ask about welfare mechanisms, highlight the court's demand for a comprehensive medical policy framework. This is high-quality, mark-fetching material.
And to wrap up, a thought-provoking scenario for your interview preparation. The panel absolutely loves testing your conceptual clarity on the separation of powers.
They sure do. So, considering the government was already planning an amendment, would you frame this Article 142 order as judicial overreach, or is it an essential piece of judicial activism for social justice? Think deeply about it. form a balanced, analytical opinion, and keep studying hard. Thank you for joining us on this Rungta IAS Academy Explainer, and we'll see you in the next one.